And our first speaker today will be John Reed from Citizens Investment Services. Thank you, John.
Thank you, Nick, and it's my pleasure to be here to provide this information for our audience. What I'm going to be talking about is how accounts typically get titled and what that means, not only from an operational perspective, but also how that ties into the probate process as well. So one of the most common forms of account titling is in the name of an individual. That's one individual that owns the account. They are the only person that has any authority over it. They have full control and full access to the account and anything that's within that account. When that person passes, all those assets pass to their estate. It funds estate expenses, and the remainder gets distributed per the will. The next most common kind of account is one that's joint, usually with rights of survivorship. And what that means is that each account owner, all the joint owners, each have 100% authority over and control of the access to the account and its holdings. And at death, the title passes to the remaining joint owners outside of probate and irrespective of any provisions of any will. So let's think about that for just a second. If we have an individual account and something happens that person is not able to handle that account, there's nobody there that can act on their stead unless we have some legal documents authorizing it, which I'm sure the other attorneys will get into. If we have an account joint with rights of survivorship, each account owner has full authority over the account, which is fine. But remember that at death, the remaining account owners get 100% of that account. So if we have a husband and wife, which is very typically the case, each has full authority. One spouse passes, the other spouse gets full control of the account. Probate is not involved in that. That happens automatically through the institution. However, if we have a situation, for instance, where grandma may want to say, hey, I want my daughter Susie to have full access to my account so she doesn't have a problem when I pass away, you can certainly do that. However, the unintended consequence might be, what happens if Susie has a divorce? Or she has some financial difficulties or bankruptcy or something along that line, then grandma's money becomes part of those proceedings. So these are things that obviously getting good advice from your trusted advisor is certainly well worth pursuing. We could also have something with a power of attorney. What that means is that an individual has a legal and fiduciary responsibility to act on your behalf over your account. This is very typical when we have a client who is getting on in years and is maybe having some difficulty with their accounts, but wants to retain control of the account. So we'll have a child come in as a power of attorney, and they're now authorized to act on behalf of that account owner. And if something should go amiss, there is the ability for legal recourse as a result. We also have something called a transfer on death. And what this means is to say, okay, the account is in the name of an individual, but at their passing, it automatically goes to a named beneficiary or beneficiaries. So this may in turn answer the issue of terms of, let's say grandma wants to have Susie help her with her accounts. That's great. She makes her a joint owner. Now Susie gets 100% of that account and the other beneficiaries get nothing. That may or may not be what grandma wants to have happen. So oftentimes having a power of attorney for Susie works very well. And then a transfer on death then names the beneficiaries in their entirety, and they then can inherit that account outside of the probate process. Another way of doing it is through a trust, which my friend Susan will be giving us a lot more attorney information about that. But basically a trust is a separate legal entity. And what this does is the assets get transferred into the trust, and the trust dictates what happens to those assets when the owner passes. It could be revocable, non-revocable. There are lots and lots of different ways it can happen. And Susan and the other presenters will provide us with some more information in that regard. If we're talking a qualified account, now let's say this is a traditional IRA or perhaps a Roth IRA or a life insurance contract, something like that. These are all beneficiary designated accounts. And what that says is that the account owner has the sole authority and control over the accounts while they are alive. Nobody else can act on their behalf unless properly authorized. At their passing, which is for in the case of an insurance contract is the annuitant or the owner of the account is then gets distributed by the institution to the named beneficiaries, again, irrespective of any provisions of the will, and it's outside of the probate process. For traditional IRAs, typically it goes to the spouse. That's what normally happens, not always, but there they would inherit it as their own IRA, and then they can handle it as if it were their own. If it's a non-spouse beneficiary, then it's what's called an inherited IRA, and time limits apply as to the account being distributed to the benefit to the owner of the inherited IRA. So these are just some things to think about. There are unintended consequences oftentimes with how we title these accounts, but this really forms the basis of estate planning. So with that, are there any questions at this point? I guess no, not hearing any then. I would like to introduce attorney Susan Pochal, who is the principal of the firm Pochal & Pochal here in Mystic. Susan, take it away.
Thank you, John. Hello, everyone. Today I'm going to be talking about trusts. And I'm sure almost all of you have heard of trusts. Some of you may have trusts. But we're going to talk about actually what they are, how they started, why they're created. They really started, we believe, back in medieval times when the knights would go off to war and they would leave their property in the hands of what we would now call a trustee to manage their property for them for the benefit of their family while they were gone. So that kind of gives you an indication of that concept. An individual, sometimes called a trustor or a grantor or a donor, creates this entity whereby they transfer their assets to a trustee for the benefit of one or more beneficiaries. So they are created by transferring assets. They can be real estate, bank accounts, investment accounts, but you give property to the trustee to manage for the one or more beneficiaries. Now, trust can be created in your will, your last will and testament, known as a testamentary trust, or it can be created while you are alive, which is a living trust, which is what most people hear about or see about in the news and in numerous publications. And these living trusts can be either revocable or irrevocable. A revocable trust can be amended or terminated at any time by the grantor of the trust. Now, a common example of a testamentary trust you might see between husband and wife. The will passes when one dies to their spouse and then to their children. But if their children are minors, you may very well see a trust established for the benefit of those minor children until they reach a particular age or ages. And you would appoint a trustee in the will to manage those assets and make distributions per the terms of the will. More commonly, we see trust agreements for living trusts. So it is in writing between the grantor and the trustee, which really tells the trustee what to do with the assets that have been transferred to them. Now, this written agreement has many terms and provisions, and they vary depending upon what the purpose of the trust is. I already gave the example of the minor beneficiaries in a testamentary trust, but you've probably heard lots of adjectives to describe trusts: credit shelter trusts, marital trusts, spendthrift trust, special needs trusts. It's the purpose of the trust or describing why it was created, which gives it that adjective, but they can be created under wills or, again, living trusts. Some of the reasons why trusts are created, for a lot of people, they're trying to avoid probate. Very interesting. A lot of people want to avoid probate, but when I ask them why, they're not really sure they can give me an answer. For some individuals, if you have out-of-state real estate, if you take that real estate and put it into a trust, then you do not have to do probate in that other state, called ancillary probate, thereby avoiding some costs and additional costs and expenses. Some people create trusts for privacy concerns. Wills do get submitted to probate. They are public record, and people can see what the terms are in the will. They do not see what the terms are of your trust. It does not get filed in probate unless litigation arises regarding the trust, and then that trust may then be part of a public record where people can see what the terms are. But it is good for privacy concerns for some people. So not everyone knows who they gave property to, how much they gave to them. Some people create trusts for management of assets in the event they become incapacitated. Uses of powers of attorney, which are talked about in other segments, can also help to avoid the need for this. But for some people, it's a very creative way for them to continue management of their assets. Other reasons, what we call spendthrift trusts. If you've got a beneficiary who is not good with money or has creditor issues, a trust is a good vehicle to manage funds on their behalf. Attorney Reardon is going to speak later about special needs trusts, so I won't go into detail on that. There are trusts which are set up very frequently for second marriage situations or third or fourth marriage situations where an individual wants to benefit their surviving spouse during their lifetime, but upon their death, pass the balance of those assets onto their own children. So that's another use for trusts. Some differences with the testamentary trusts versus living trusts. A testamentary trust is subject to probate court supervision. So for some individuals, if they think the trustee may need a little bit more supervision, then they may want a testamentary trust. There are accountings that are required to be filed, and there's costs involved with that. And so for some people, they prefer to use a living trust format so they don't have the formal accounting proceedings. Not to be confused with probate and taxes. A lot of the argument you hear about living trusts are avoid probate, avoid taxes. And taxes are one of the reasons why some people may create trusts. But avoiding probate and avoiding taxes has nothing to do with avoiding probate court fees. So just to clarify, whatever assets you may own at the time of your death, whether they're individually owned, as John talked about, or jointly owned, as John talked about, or in a trust, an individual still has to file that estate tax return and pay the probate court fees. And that's the way it works in Connecticut. In many other jurisdictions, it does not work like that. Trusts are incredibly useful if they are funded, meaning you actually do take your assets and put them into the name of the trust. And if they are funded, they avoid the probate process. And in other jurisdictions, avoiding that probate process can avoid a difficult process, formal process, and expensive process. One of the other reasons that people creating trusts, again, trying to avoid probate or think they're avoiding probate. Again, in Connecticut, don't avoid the probate court fee. But the important part really of these trusts is the trustee itself. And the trustee can be an individual, or it can be an entity such as a corporate trustee. And we are going to have Holly Knott from the Washington Trust Company talk about corporate trustees in a moment. But I want to talk about the importance of choosing the trustee. And the trustee's job is to manage these assets. They've got to file reports and accountings depending on the terms of the document or statute. They need to file income tax returns because the trust is a taxpayer, and they have to make distributions in accordance with the terms of the trust. So they have a job to do. So you've got to make sure that trustee has the right qualities. They should have some administration or accounting abilities. They need to have an investment philosophy that's compatible with yours. They should be available to the beneficiaries. They should be neutral and fair with the beneficiaries. They should have, of course, integrity and a reasonable fee structure. But they also need to be sensitive to the needs of these beneficiaries. And the trust can be very complex in terms of what this grantor of the trust is actually trying to accomplish. In many instances, again, for the benefit of a spouse and then for children, which could have varying needs, which is why Attorney Reardon is going to talk about some special needs trusts. But with regard to the trustees, again, it could be a difficult job if you don't put the right person or entity in charge. So we will probably lead into Holly talking about the corporate trustee and the benefits of in choosing that for your trusts. Holly?
Thank you, Susan. Hi, everyone. I'm really pleased to be talking with you today. I'm, again, from Washington Trust Wealth Management, but I'm also currently serving as president of the board of the Estate and Tax Planning Council of Eastern Connecticut. So we're really pleased to be bringing the series to you. Quite a bit of work has gone into the planning and implementation of this series. So we sure hope you find it informative and gives you some information to help start a conversation. If you would like to meet with an attorney to discuss creating a trust, certainly. So when you are creating a trust, there are a lot of very important decisions that need to be made. One of those is who you will name as your successor trustee. Typically with a living trust, as Susan talked about, you serve as your own trustee while you are living and competent. And at such time you can no longer serve, you need to name someone in that document who can step in and replace you. So when you serve as a trustee, you have a fiduciary responsibility, and it does require knowledge about investments, accounting, reporting, tax consequences, and oftentimes legal expertise. So if you have a family member who you're considering naming as a trustee, you really want to make sure they have the ability and are willing to accept the responsibility to take on this important role. So you are able to name a loved one or a family member and a corporate trustee to serve jointly as co-trustees. And this arrangement we find works very well because the corporate fiduciary can take on all of the heavy lifting, the tax reporting and accounting and legal aspects. And then the personal or independent trustee, the family member, can be involved to the extent that they would like to be. And maybe, are part of the conversation about what the investment strategy is going to look like and distributions. But again, all of the fiduciary duties, if you will, are taken care of by the corporate trustee. So some of the key reasons you may want to consider using a corporate trustee instead of a family member. First and foremost, if you have a corporate fiduciary ready to step in, it allows the family to go through the grieving process and, thinking about losing, their loved one, and not have to worry about any of the administrative tasks that can be handled by the corporate fiduciary. Another important reason to name a corporate trustee is when there is a second marriage and maybe there are kids from a previous marriage. So someone might want to put their assets in trust to make sure that their spouse is taken care of financially for the remainder of their life, but that their assets ultimately will pass to their heirs. And a corporate trustee, having a corporate trustee in place in that situation eliminates any strain on the family dynamics and really makes sure someone is looking out not only for the interest of the current beneficiary or the spouse, but is mindful of the interest of the future beneficiaries. Another reason to consider a corporate trustee are when there may be strained family relationships or when siblings have different needs. So often at Washington Trust, we see situations where maybe we're just serving as investment manager and mom and dad passed away. Let's say they left an estate of $2 million and they have $1 million they'd like to leave to David in trust. Because maybe David doesn't have financial acumen or has had some substance abuse issues. So they're really not comfortable just leaving him $1 million. So they put it in trust and they name David's sister, Sarah, as trustee. And the $1 million that Sarah is inheriting goes outright to her because she has some financial acumen. Well, unfortunately, what happens in a situation like that, David and Sarah's relationship can become strained because if David wants to take a discretionary distribution from the trust and Sarah doesn't think it's a good idea, and maybe it doesn't conform with the intent of the document, she has to tell her brother no. And so that really sometimes can devolve into a really bad situation where there's strain on the family relationship, and having a corporate trustee in place would really just reduce that trouble, that worry, and would allow for someone to be making objective decisions and not put a strain on that family relationship. Let's see. It can also be important to name a corporate trustee if the beneficiary has spendthrift issues, drug or alcohol dependency, health or mental health issues, or are involved with creditors or going through, or the possibility of going through a divorce. So again, it's good to have corporate trustees when any of those issues are a concern for the beneficiary. And of course, with a special needs trust. And again, Jack is going to really get into the details there, but Washington Trust really enjoys working with special needs families and special needs trusts. It's a very unique type of arrangement, but you definitely want to involve a corporate trustee there because the rules and regulations can and do change often, and you want to make sure you're adhering to those rules. So a professional fiduciary can provide objective asset management and distribution decisions. Sometimes when there's two spouses and maybe one of the couple is handling all of the financial aspects in the relationship, bill payment and managing the investments and paying the mortgage and things like that. It's a good idea for a corporate fiduciary to be involved there. Should something happen to the spouse who's managing all of those things, then the spouse who may be either by their own choice or not, but maybe in the dark about these things, would really have the guidance of a corporate trustee to help them with all of those decisions. They also provide a professional approach to family dynamics, which we all know can be very interesting from family to family. A professional fiduciary provides financial accountability and record keeping. Continuity of the administration of a trust and bill payment. Again, in the case of a couple, if maybe one spouse is incompetent or living in assisted living, if the other spouse passes away, you want to make sure there's someone who is willing and able and ready to step in, so there's no disruption in care or services that the remaining spouse may need. Also, the fiduciary would prepare the tax returns for the trust and any fiduciary reporting that might be required due to a charitable remainderment or something like that. And again, a professional or corporate fiduciary will always adhere to the duty and standards of care required of a fiduciary. And again, so important to balance the current beneficiary's needs with future beneficiaries' interest. So it's interesting, the fees for hiring a corporate fiduciary generally run just a bit higher than if you were going to hire someone to manage your investments. So for all of the added risk and duties that they take on, there's not a lot of extra cost involved if you are already paying someone to manage your investments. So it's important when you meet with your estate planning attorney, if you are creating a trust or thinking about making an amendment to your trust, if you're considering naming a corporate fiduciary, you really should have a conversation with that institution to make sure that their fees are reasonable, that you understand them. A corporate fiduciary may also have a minimum asset threshold that they require. So you want to make sure you understand that. A corporate fiduciary can also manage, some of them, not all, but can also manage unusual assets such as mineral rights or business interests or things like that. But again, it's important to understand what they can handle and what they would charge to do that. And again, typically, if investment management fees are around 1%, a corporate fiduciary fee would be just slightly higher than that. I think they range probably from about 1 to 2% of the assets under administration, depending on the institution that you work with. So I'll leave it at that. If you have any questions, please feel free to visit www.washtrustwealth.com. You can find my picture and email address. Feel free to send an email. I'm happy to answer any questions that I can. And with that, I will turn it over to Attorney Reardon to talk about special needs trusts.
Hello, thank you, Holly. So the topic I'm going to cover today is special needs trusts. And those are a subset of trusts, as you heard Attorney Pochal discuss. It is a very broad area, but I'll try and give you just a brief overview of the main types of trusts that are considered special needs trusts and why you might need one of these. First, the main purpose of a special needs trust is to hold assets for a person who has special needs, either because of a developmental disability that they were born with, or because of a disability they incurred later in life, either from an accident or an illness that affected their capacity to care for themselves. So, these types of trusts really have two purposes. One is to designate a responsible trustee to manage the assets for somebody who you might deem incapable of doing it for themselves. Another main purpose is to make sure, excuse me, that if the beneficiary is receiving any type of government aid, whether it's Medicaid or supplemental security income, that they do not become ineligible for those programs because of the asset that they've received. So let's talk now about some of those programs that we would be concerned with. So programs like supplemental security income and Medicaid, they're referred to often as means-tested programs because they're only available for persons who meet certain asset levels and certain income levels. For instance, in Connecticut, the asset level for Medicaid in a nursing home, a person can't have over $1,600 in assets that are in their own name. And their income has to be below a certain level to also become eligible. SSI is another program that supplements a person's income if they have low income and do not have enough money to afford to live. Often people who live in an assisted living facility will be receiving SSI and will rely on that as a necessary form of payment to help them stay there. So there are really two instances when special needs trusts are helpful. The first is if a family member wants to leave an inheritance to somebody with special needs, but they don't want that money to make that person ineligible for a government benefit program. Often without these types of trusts, a person's faced with a choice of giving an inheritance to a child who is going to have to lose eligibility for a temporary time for a program and spend down all that money before they again resume being eligible. Many people think that's not desirable, and they could just instead disinherit that child and give everything to other family members. But with a third-party special needs trust, that's not necessary. You can leave the asset in a third-party trust, and the person, if it's drafted correctly, will not become ineligible. So let me then introduce you to the main two categories of special needs trusts. The first type is referred to as a third-party supplemental needs trust. And the second type is referred to as a first-party special needs trust. And the difference between the two, one of the main differences is the source of funding. As I just referenced, a third-party supplemental needs trust is a trust that's funded by a third person. So it's usually a parent, a sibling, a grandparent, an aunt or an uncle, or just a friend who wants to leave something to care for the disabled person. This type of trust, is established by that third party, which is why it is referred to as a third-party trust. Once the supplemental needs trust is established, anybody can contribute money to that trust to leave an inheritance to that disabled person, except that disabled person himself or herself. So the trust becomes a vehicle for other family members to contribute funds to the disabled person if that's desirable. For these types of trusts, the beneficiary can be of any age, and it can be funded during the life of the person creating it, or it can be funded at death, either by a will or by a beneficiary designation from, say, life insurance or a retirement account. And so it's one of the reasons they call this a supplemental trust is because it's intended to supplement government benefits that a person is receiving without supplanting those benefits. So the reference supplemental needs trust. An important distinction between this type of trust and a first-party trust is that there is no payback provision. You'll often hear payback provisions referred to when people are discussing special needs trusts. And that is referring to a requirement under a first-party special needs trust that upon the beneficiary's death, the state is allowed to recover all amounts that it has expended on behalf of that person from the trust before anybody else can get any of the balance. So that is often a very important factor that people consider. They can then leave the balance to other siblings of the disabled person, or they can leave it to a charity or any person they desire. Now let's now talk about the other type of special needs trust. That's a first party special needs trust. And as you can imagine from the name, it's a first party special needs trust because it's funded with the beneficiary's own money. This often occurs when the person has received an inheritance outright, or maybe they've been in an accident and they've received an award for personal injury or a settlement for personal injury. Or sometimes it's used to hold the person's monthly income in order to get them eligible for benefits that require a low monthly income. Now, these types of trusts, you'll actually have two subcategories, and they're referred to often as a D4A trust, or often practitioners just call that the special needs trust. And then there's the D4C trust, which is often referred to as a pool trust. And those letters come from a long site, 42 USC 1396P, D4A and D4C. So you can see why people just shorten it down to the last few letters of those sites. Now, the distinction between those, as we said, the difference between that and the third-party trust is it's funded directly with the person's own money. Now, there are important distinctions between the D4A trust and the D4C pool trust. So the D4A trust can only be created for a person who is under the age of 65. And it can be created by the disabled beneficiary themselves. It can be created by a parent, a grandparent, or a guardian of that disabled person. Or if none of those people are available, you can go to the probate court and have the court issue an order creating such a trust. For a D4A trust, you can choose who you would like to be the trustee of that trust, which makes it a lot more flexible than the pool trust type of trust. But another very important distinction between that and a pool trust is the payback provision. You are required to have a payback provision. You have to pay back the state up to any amount that it paid on behalf of the beneficiary for any government benefits at that person's death. But any balance can go to anybody designated by the person who sets up that trust. In contrast that to a pool trust. Excuse me. A pool trust, again, is funded with a beneficiary's own money, whether it's, again, from an inheritance received directly or proceeds of a lawsuit or the disabled person's income. A distinction between the pool trust and the D4A trust is one, the trustee of that trust. As unlike a D4A trust, you cannot choose who the trustee is. There is, each state approves a list of nonprofit organizations that can serve as a trustee of a pooled trust. In Connecticut, there's only one, that is Plan of Connecticut. And they administer that trust along with other trusts of people establishing these as a pool. This is why it's referred to as a pool trust. So they're invested together, but they are kept track of separately so that each person is deemed to have an individual account. Again, like a D4A trust, these can be created by the disabled beneficiary, by the parents, grandparents, or a guardian of that disabled person, or if those aren't available, it can be created by the probate court. So one distinction here, as I referred to before with the payback provision in a pooled trust, again, you do have to pay back the state for any funds that it's expended on behalf of that disabled person upon his or her death. And then the balance, if any, there are two choices that you can make when you set these up. You can either go into the pooled trust fund itself to be used to help supplement other pooled trust members who have low funds in theirs, or it can all be paid to the state. So that is an important distinction that, between that and the D4A trust. You have no control over who's going to get the money at the death of the beneficiary. Now, as you can see, this is quite a complex area of law, but that's just a little bit of an overview of those types of trusts. Does anybody have any questions?
Anyone wish to question or comment?
This is John Reed. I just had a general observation because I've dealt with many clients who have been, if you will, the recipients of beneficiaries of trusts or been acting as trustees. And that gets into the area where the grantor has established more than one trustee and specifies that they should be acting as co-trustees. And from an administrative practical point of view, a sincere request is that the trust documents specify whether those trustees are to act jointly or severally. If it's silent, my institution treats that as jointly, which means that in order to make any changes or do anything with the accounts of the trust, I have to have the consent and authorization of all the trustees, which can be a bit of a burden at times. But on the other hand, if it's saying they're acting severally, then I can act on the authorization of any one of the trustees, and that simplifies the administration. But it really depends upon, what the wishes are of the parties involved.
Yeah, I would say that's a good point, John, and that's why it's important to draft trusts to address those issues. Whether you want to give one trustee the authority to act alone for certain types of activities, but have to follow the requirement of both trustees joining in for other decisions. That's something that should be addressed in the document itself.
Mm-hmm.
Anyone else wish to comment on any of the respective presentations while we have a little time here? My comment from the probate court perspective is that, just like we talked in an earlier session about the importance of using a will to express your wishes, I just want to share that my observation, if you will, over 9+ years as the probate judge for the region is that I'm always amazed that more people don't utilize these tools of a will or a trust or management of their non-probate assets in various ways to create an estate plan. People spend their lives amassing oftentimes significant assets, and they put up a Herculean effort into creating those assets. Yet not everyone by any means, but far too many people don't then make the effort and spend a little money to create an integrated plan. I was thinking about this over the weekend that friends of mine that I went to college with worked in Washington, D.C., and then because housing costs were so high in D.C., they bought a home in Baltimore, even though they both worked in Washington, D.C. So for the better part of 15 years, they would get up in the morning, walk to the train station, take a train to DC, once they got off the train, they'd have to take a subway. One of them later in her career had to work in Northern Virginia, so it would be walk, train, subway, bus to get to work. The reason I bring that up is their goal was to get to work, but they had to use different vehicles, different modalities, different tools to achieve their goal. And my perspective is that estate planning is like, and it's all about the effect of will. It might be a trust, it might be a power of attorney, it might be designation of assets, because people don't understand that the way you title your assets, as John eloquently, has a huge bearing on your estate plan. So people are routinely doing kind of ad hoc estate planning by how they title their assets, whether it's jointly owning their home with their spouse, or naming an beneficiary of an insurance policy, or on and on for the non-probate assets. They do it kind of on an ad hoc basis without any real plan, and then something happens and it's not an integrated plan. So the reason the Estate and Tax Planning Council of Eastern Connecticut exists is to promote the idea to the community of being more thoughtful about your estate plan. And so I commend the Estate and Tax Planning Council for doing this session. This is a follow-on to a series we did 6 or 7 years ago, which was very successful. I particularly commend the council for not being daunted by the pandemic. We're not able to do a series like we did 7 years ago, where we went out physically into the libraries, out into the community. So we're trying to use technology to try to continue the mission of the council to educate the community about the benefits of estate planning. So I commend the council generally for hosting this. I want to urge people to the website of the Estate and Tax Planning Council of Eastern Connecticut, which has a list of members of all these talented people who do this sort of work. I also want to thank especially the presenters. People have taken their time today and spent considerable time preparing presentations. And so Susan, John, Jack, and Holly should all be commended for this. No one's getting paid to do this, so you're to be commended for giving up your time to help the community be more informed. Similarly, the Seaport, kudos and shout out to the Seaport for hosting this, and in particular Chris Freeman for hosting today's session. We've all got busy lives, we all got things to do, but this is important, and people need to think through these activities, because it can have life-altering consequences for folks. So I want to extend my appreciation. Anyone else with any final comments?
I'd like to add one final thing. It's a common situation that I run into, and I'm sure we all do. And that has to do with parents wanting to gift their home to their children. Ostensibly, this is often taken as part of a Medicaid planning strategy, but the idea of it is mom and dad quitclaim or gift their house to one or more of their children so that it's no longer in their name, but they obviously would have a lifetime tenancy there. The issue with that is that that's all well and good. However, now that the children are the ones that are responsible for the house, they are responsible to pay the taxes, they are responsible for its upkeep, all those good things. But also what happens is when mom and dad pass away, the house is now in the name of the children, and I'm assuming the children have not been living there, so they decide, do they want to keep the house or not? If they decide they want to keep it, that's one thing. If they decide they want to sell it, all well and good. However, taxes become an issue. Because when mom and dad gifted the house to the children, they gifted not only the value of the asset, they also gifted to them the value of mom and dad's cost basis for that house? This is a question for an accountant to help you with and a good estate attorney to help you with. But just be aware that if you are the child in that situation, you're planning on selling the house, be prepared. You're going to have a capital gains tax more likely than not. So just as a word of advice.
Thanks, John. And there are, as Susan knows and Jack knows, there are some strategies that can be employed to address those consequences. Again, thank you for your nearing our hour. We're trying to keep these sessions to an hour. There's another session later about Title 19 and impairment planning, and we encourage everyone to join in. And we thank the viewers for joining us today about estate planning. Thank you all once again. Appreciate it.